Planning Blueprint, where we give tips on estate planning for lawyers, financial planners, and anybody else interested in learning best practices for estate planning. And today, I'm going to be talking about asset protection trusts and how they work. So the first part is what I'll call a lawyer's guide to asset protection trusts. So I'm going to go through some of my thoughts about what they're all about, when you should use them, what type of trust to use for this purpose. And then I'll go into how I explain it to clients. And that'll give you an idea of how they work from the standpoint of a client. We'll go through an example. And what I think I'll do, you've seen kind of the behind the scenes look here of how I'm doing this with a live stream, is I'll take the part where I'm explaining it to clients. I'll make a separate video on that and post that to YouTube. And I'll also have the full live stream as well. So if you're not able to stay for the whole thing, you can watch the rebroadcast later. And then I'll of course be here to take questions. If you tuned in, you have some questions about this. When the explanation part for the client's all over, I'll be able to take your questions here, or if you're watching later on a rebroadcast on the live stream, you can leave comments you can leave your questions in the comments, and I'll be able to answer them there. So, asset protection trust. First of all, let's get into some definitions so that it's clear what we're talking about. So we're not talking about the type of irrevocable trust that you would use for federal estate planning purposes, for example, like an irrevocable life insurance trust. That's a whole other different type of animal. And we're not talking about something like a domestic asset protection trust that are authorized under some states and I think are used by higher net worth individuals to shield assets, or a special needs trust. We're talking about the more garden variety asset protection trust used by a lot of elder law attorneys to help their clients avoid things like nursing home spend down, right? Because we can see a lot of our clients facing the prospect of qualifying for Medicaid, but they have so many assets that might potentially have to get spent down in a Medicaid asset protection plan, that if we plan further ahead, we can get a better result for clients. So that's the type of trust that we're talking about. But I don't want to limit it just to Medicaid, because there are other ways that it's helpful as well. So if somebody would be in an accident, let's say, maybe as you get older, you have less ability to drive safely. So you might cause an accident, right? So it can protect you from maybe a huge judgment, something like that. Or scam artists, putting up some obstacles in the way of people that call on the phone and try to wheedle people out of their money. So a lot of hazards out there. Undue influence is another one. So a lot of things that people face in their elder years that can be addressed by these trusts. And typically what we're talking about is a grantor type trust. So not going to go heavily into the tax implications and everything, but if you do some research on the difference between grantor and non-grantor type trusts, you'll see that a grantor type trust is tax neutral. It's not going to affect things like step up in basis. Whatever you put into a grantor type trust is going to be subject to step up in basis upon death. Okay, so people preserve these tax advantages that they have normally and won't be affected by putting something in a trust and having it affect their basis for capital gains tax purposes. So typically when we're putting a house and other assets into an asset protection trust for seniors, a lot of times we're going to be using a grantor type trust. I want to address some of the terminology too. So I'm calling it an asset protection trust. And I think that's fairly common among elder law attorneys. But the same type of trust that I'm talking about, so this would be like an irrevocable trust, grantor type trust, designed to get past a 5-year look back period for nursing home spend down purposes and protect against other assets, but still leave the grantor of the trust some aspects of ownership, like the ability to change beneficiary, things like that. That's a type of trust that we're talking about. And I've seen a trust set up for that purpose called a lot of different names. So besides asset protection trust that I use, I've also seen it referred to as a Medicaid asset protection trust, or MAPT. Another one is an irrevocable income only trust, or IIOT, IOT. There's a group called Lawyers with Purpose that uses the term IPUG, which is essentially, I believe, still an asset protection trust, grantor type irrevocable trust. And then there's my least favorite, and that is the intentionally defective grantor trust. And I understand why it's called that, because it has to do with the tax rules and being defective. But I don't think it's good public relations with your clients to call the trust that you wrote for them an intentionally defective trust. I think we can just scrap that terminology altogether. So the intentionally defective grantor trust, or IDGT, IDGIT, and also the Medicaid intentionally defective grantor trust, or MIDGIT. I think the IDGIT and MIDGIT, they sound like slang terms that are not very appropriate for most people. So I think we can skip a lot of that terminology. And people always ask about forms too. Where can you find forms? There are different publishers in various states that will produce form books that you can use for wills and trusts and this sort of thing. So sometimes they'll have this type of trust as well. There are other services like Interactive Legal or Wealth Counsel that are set up to do all types of estate planning drafting, and they have very sophisticated systems set up, and they will include irrevocable trusts for this type of purpose as well. And also, a group like Lawyers with Purpose, would, I believe, have their own proprietary trust forms that they use. So a lot of different sources out there to find forms. Now, before we get into the explanation to clients, also want to address the issue of whether this is suitable for your client. All right. So typically, this is not for everybody. Right? Some people have too little to justify it. It's probably not worth. It's probably not going to be worthwhile with high net worth clients, right? And where I make the distinction is if somebody can pay for any type of long-term care out of income, if you've got enough in your investable assets to, if you got income from that at say 4 or 5% a year, and you were able to pay for any type of long-term care out of that, I would say then there's no reason to do this type of asset protection trust unless you're trying to achieve some other goal like protecting against undue influence or judgments or something like that. But the sweet spot for it, I think, is that like middle 80% of the elderly population. And typically it's elderly people that would be interested in this. Somebody just on the cusp of retiring, 60, 65, something like that, might be too restrictive for them. But people in their 70s and 80s, and if you think of populations dispersing on a bell curve, right, with the tail ends being people with very little, and then high net worth people being on the other end of the tail, it's that bell curve middle 80% that is typically in the sweet spot for doing some type of asset protection trust. Also want to mention that it's not something that you would want to use as a vehicle for retirement accounts, because retirement accounts have tax consequences. If you would try to put that into a trust, it would be considered a distribution by the IRS. And that's probably not what you want to do with clients. Although there are exceptions. There are times when maybe we'd want to, cash it out and put something in an irrevocable trust. But you have to consider the tax consequences because they can be quite significant. And I'll mention that in the explanation. So that's an introduction, and that's sort of my lawyer's guide part. And now I'm going to switch over to, in the live stream, to giving my explanation for how I explain this to clients. And again, I'll make this a separate video and post that to YouTube. So you can go and look at that separately. And then when that's over, I'll come back and take any questions that you might have. So this is the first time using slides in my live stream presentation. So we'll see how this goes. There we are. There's the slides. So I'll go through this, and when I'm done with this, be happy to address any questions people might have. Okay, so if you're thinking about using an asset protection trust, I want to give you this explanation of how it works. So it's typically for non-retirement accounts and other types of property. It's fully protected after 5 years because when somebody applies for Medicaid, the question from people is, have you given any assets away or transferred anything to a trust in the last 5 years? And if so, there's going to be a penalty that applies. So after 5 years, you don't have that issue anymore. That's why after 5 years, we can say that it's fully protected. You might get some benefit up and to that point. As, for example, if you created an asset protection trust and 4.5 years goes by, then we can use maybe assets outside the trust to pay for a nursing home for the next 6 months and get past the 5 years. So there still is benefit, and we're protecting some of the assets the longer it goes on, but it's fully protected after 5 years. If it's set up the right way, it can preserve your tax advantages. So typically what we're using is something called a grantor type trust, and that'll preserve tax advantages such as step up in basis. If you have appreciated assets, this will be helpful to you when somebody dies, that it eliminates the capital gains tax. Also things like a residence. If you have a personal residence that you're putting into a trust, then you get the exclusion from capital gains tax if you've lived there for the last 2 out of the last 5 years, right? You get a certain amount that's excluded from capital gains tax. That's another tax advantage that gets preserved. And things like you don't have to file a separate 1041, a separate estate or trust tax return for the trust, because you can report any income on your 1040. So these are some real tax advantages that can be preserved when using the right type of trust. You can serve as a trustee if you've got good capacity and you can manage your own affairs. Then there's the ability to serve as trustee and manage what's inside the trust. We can also set it up so that you can change beneficiaries. This is going to depend on why you're doing this. So if there's a concern about the person setting it up being subject to undue influence, maybe we would want to limit the ability of that person to change beneficiaries. But in a lot of cases where we don't have that concern, we would set it up so that they're going to tell me up front. The client tells me who they want to leave this to when they're gone, and then we preserve for them the ability to change those beneficiaries if they so desire. So in a lot of ways, it seems like the person that's setting up what is an irrevocable trust still has a lot of the incidents of ownership, right? So if you can serve as trustee and control what's in it, and also change beneficiaries, it kind of feels like you still own it in a lot of ways, even though you don't have the same direct access to it as you would if it's in a revocable trust or if you own it in your own name. Now, there is indirect access to the assets, so we have to be very careful about who we set up as beneficiaries. And we'll typically write in some provisions into the trust so that the trustee can make distributions to a beneficiary. So that's how we have indirect access, is through a beneficiary. It'll go like this. Let's say there's $500,000 in the trust, and the grantor of the trust is serving as trustee. And he decides, well, I'm going to make a distribution to one of my children because those are the beneficiaries. I'm going to write them a check out of the trust for $40,000. It's theirs legally. But I'll ask them, would you mind, once the check clears, writing a check back to me, and then I'll have $40,000 to buy a new car. Okay, so it's not coming directly out of the trust. We're honoring all of the formalities of the trust and having it go from a trust to the beneficiary, and then after that, the beneficiary can do with it what they want. So we preserve the formalities of the trust, but still have indirect access for the grantors. So a lot of people, when they're setting it up as the beneficiaries or their children or somebody close to them like that, they're comfortable with that and are willing to create a trust like that, knowing that they'll get asset protection as time goes by. All right, so let me give you an example of how this might work. And I'll preface this by saying that I practice in Pennsylvania, and this is set up according to how Medicaid works in Pennsylvania. Now, Medicaid is a federal program, but it's administered by the state, so it's a little different in every state. And your state where you may be watching this might be different. But in Pennsylvania, one of the differences here is that qualified retirement accounts are considered exempt assets for Medicaid spend down purposes. And so on this slide here, I'm giving the example of Abe and Mary, and they have certain assets. One of them is their house, and their house is in red because that's exempt. It's not countable when we're doing Medicaid spend down. Investment account, $400,000. And then Abe's and Mary's IRAs I have is a lighter shade of red because there is some exemption in Pennsylvania for Medicaid purposes. So if Abe is in the nursing home, Mary's IRA is exempt. If Mary's in the nursing home, Abe's is exempt. It's for what they call the community spouse, the spouse at home when somebody's applying for Medicaid. So those are going to be exempt depending on who's in the nursing home. Their joint checking, $50,000. That's going to be countable in all situations. And they have a total estate of $1.1 million. All right, so I'm not going to go through all the numbers and explain why you end up with a certain amount to spend down, but I've done the math, and this is how it works in Pennsylvania. Probably similar in other states, but the main thing here is to show you the actual functionality of it. So if Abe was in the nursing home in Pennsylvania, their house would be exempt and Mary's IRA would be exempt. So these other assets would be countable, and Mary would be entitled to something called a community spouse resource allowance. So she'd be able to keep some of this, and out of their 1.1 million, they'd have to spend down about $504,000 before qualifying for Medicaid. Now, if Mary's in the nursing home, numbers are similar, but because of the difference in the IRA amounts, you'd only have to be spending down around $404,000. So this is what would happen without using a trust. If they had these assets today and somebody had a stroke tomorrow and needed to be in the nursing home the day after that, this is how roughly the numbers would work. Now, suppose we create an asset protection trust, and in it we would put the house and their investment account of $400,000. So they'll have a total amount of $750,000 in the trust. Now, let's go and see before and after how this would affect their spend down. So before, remember, if Abe was in the nursing home, we're spending down over $500,000. If Mary's in the nursing home, spending down over $400,000. But after 5 years, when the trust has been in existence and been funded for more than 5 years, it would look like this. This is the after. All right, so now we don't have that big investment account in there to be part of the spend down. So the way the numbers work out is if Abe's in the nursing home, spending down a little over $100,000, $117,000. If Mary's in the nursing home, spending down $67,000. So let me just toggle back and forth here. Before, $500,000. If Abe's in the nursing home, versus spending down 117,000 before for marriage, 404,000 after 67,000. So you see, it makes a huge difference, hundreds of thousands of dollars that are being protected by planning ahead and knowing that there's that 5-year window that if we can get past, we can have a lot of savings. So it's the benefit of planning ahead. So what we've ended up with after the 5 years has passed, we have this trust with the $350,000 house in it that is not going to be subject to being spent down, or even if it's exempt, there's something called a state recovery that after you're gone would enable the state to come back and recoup their Medicaid costs. Okay, so if it's been in a trust, it can be shielded from that as well, depending on your state. Some states are different, but in Pennsylvania, anyway, if it's in this type of trust, it would be shielded from a state recovery. And investment account, $400,000, that's part of it too. So we have this nest egg for the beneficiaries of $750,000 that's going to be protected for them. Again, if we get past the 5 years. Now, it's not the worst thing in the world if something happens in the middle, like after 4 years, somebody needs nursing home care. Maybe we'll, at that point, make a distribution to one of the beneficiaries, and they'll pay for the nursing home for that last year, so that we get past the 5-year look-back period, and we've protected most of it, but not all of it. So the longer somebody stays healthy and out of a nursing home, the more it can be protected in an asset protection trust. So that's how an asset protection trust works. It's something that a lot of elder law attorneys do, and if you're thinking of this, you should go and consult with somebody who has extensive training in this, like a certified elder law attorney or somebody with a lot of experience doing Medicaid planning and estate planning to help you set up the right type of trust to give you this type of protection. Okay, so that's how I explain the asset protection to clients, and particularly the asset protection trust. So now I have time to take questions if anybody has questions. Again, on these, if you've been tuning into these live streams, we have a small audience at this point because we just started these about a month ago, and we're still building up our audience. I can tell from the analytics that we are getting people watching every time, and probably not enough for people to have questions at this stage of the game. So I don't usually get a lot of questions. Just a couple of times have I gotten questions, but I always do want to allow this opportunity. And I'll mention too that if you've gotten value out of watching this, please like and subscribe. That helps us. You can go to our YouTube channel and do that. And I'll mention this for the YouTube video as well. If you like what you've seen and you're getting value out of it, please like and subscribe, and that helps us to reach more people. Now, one question that I often get with asset protection trusts has to do with the funding of it. All right, so the funding of it is what determines when that 5-year look-back period starts. So for example, if we're putting the house into the trust, then whatever the date on the deed is, that's going to determine the funding date. Excuse me. If it's, as we saw in the example a minute ago, an investment account, then it'll be whenever that investment account gets transferred into the name of the trust. So that's what funding is all about. And the funding date is what determines when that 5-year look-back period starts. It's not affected if the house is later sold. So sometimes people that put a house into a trust like this will want to sell the house and downsize. Once it's been put in, that's the beginning of the 5-year look-back period for that asset. Then if it's later sold by the trust and the proceeds come back into the trust, and then the trust purchases a house of lesser value, so we're downsizing, those are still things that are in the trust, the smaller house and the proceeds of the sale. but it doesn't begin any type of 5-year look back period over again. The only thing that starts a new period, a new period of the 5-year time span would be if you add new assets. So if we started out putting a $350,000 house and a $400,000 investment account in at the beginning, and then a year later added another $100,000 in savings bonds, the $100,000 savings bonds would be subject to a later look back period. But the 5 years on the initial assets would still be running on the original schedule. So those are the basics of an asset protection trust. It's an extremely powerful vehicle to help protect assets for clients from things like nursing home spend down, and also things like, if somebody's trying to bilk them out of their money, they get scam artists calling on the phone. Whoever is serving as the trustee is in charge of those funds. So it's going to be a lot harder for somebody to do that if things have been set up into a trust and you're trying to get money out of somebody. It can be really sad if somebody is subject to scam artists like that. They used to be pretty sharp, but now they're more liable to be bilked out of funds. So using a trust for that purpose can be extremely effective. Okay, I'm not seeing any questions at this point. So at this point, I'll just say thank you for watching and tune in next time. Oh, wait, there's a question. Hold on. Bob has a question. Bob, you got in just in the nick of time. Okay, I may have missed this, but are there types of accounts or assets that should not be put into an asset protection trust? Okay, great question, Bob. Yeah, we covered that early on. So the main thing that you want to be aware of is don't use this type of trust for any type of retirement accounts. So IRAs, 401ks, 403bs, anything of that nature. Because if we put that into a trust, that's going to trigger the tax due. And the tax due can be quite massive in some cases. And it's going to prevent, excuse me, it's going to prevent that asset from growing tax deferred the way it does. Because retirement accounts can be great assets, not only for the individual, but also for the heirs. So typically, if we're doing like Medicaid planning for people, we'll have other solutions for how to spend that down in a way that's going to be as protective as possible. So in most cases, it works out best to put the non-retirement accounts into the trust and then have another plan for the retirement accounts. Okay, great question, Bob. I'll just wait a minute, see if there's anyone else. We've been doing these live streams on Tuesdays, and that's worked out really well. It looks like the audience is growing each week, so I really appreciate everybody tuning in. Tell your friends, share the link if you have the link, and that'll be a way to expand our audience here. And if that continues, we can keep doing this and providing this information to people every Tuesdays while they're having their lunch. Okay, I don't see any other questions at this point. Thanks again for tuning in. See you next time.